organization. And this could be the reason the employee resigns from the present job. So resignation is voluntarily when an employee quits his employment. That is the meaning of resignation. Now, the second voluntary retirement or voluntary separation type is retirement. Now, again, everyone is aware of what is retirement. So we will not get into detail of what is retirement. In simple words, retirement means when a person, when the employee attains the age where he has to leave the organization. On attaining that age, when the employee leaves the organization or quits the organization, that separation is called as retirement. Now, at the time of joining the organization, when the employee receives the appointment letter or offer letter from the organization, on that appointment letter or offer letter itself, it is mentioned that the retirement age of the employee will be, say, 55 years, 58 years, 60 years, 62 years, 65 years, 67 years, or 70 years, whatever the policy of the organization is. It varies from organization to organization. Suppose the organization has a policy that an employee on reaching the age of 55 years has to leave the organization. That means the retirement age for that particular organization is 55 years. So any employee who turns 55, after that, he has to leave the organization. He has to separate from the organization. And that separation is called as separation by way of retirement. Now we will be talking about the involuntary type of separation. Yesterday only we had discussed that voluntary separation means the separation which takes place because of the employee. Employee voluntarily leaves the organization by way of resignation or by way of retirement. But when we talk about involuntarily, here employee wants to be in the organization, but the organization doesn't want to keep that employee in the organization. One of the reasons can be that the employee is not a productive employee, or the employee has committed insubordination on various occasions. He is not following the orders of his seniors. So that employee who wants to stay in the organization because of some reason, the organization doesn't want that employee to stay in the organization, and the organization make sure that the employee is separated from it. That is called as involuntary type of separation. Now, under involuntary type of separation, first one which we are going to discuss is discharge and dismissal. Now, discharge and dismissal both are the form of separation which are called as permanent in nature. When permanently an employee is separated from the organization, that is called as discharge or by way of dismissal. Permanently, the employee is separated from the organization. Now, there is a difference between these two terms, discharge and dismissal. One thing is common in both discharge and dismissal, and that is that it is permanent way of separation. The employee is not going to join the organization again after some time. So it is permanently. When an employee is permanently separated from the organization, that is discharge or dismissal. The common meaning, the differentiating factors or differentiating things for discharge and dismissal is discharge is considered as less severe than dismissal. When a person is discharged from the organization, it means that this is considered as a less severe punishment given to the employee. But when we say that the employee has been dismissed from the organization, it is considered as a severe punishment given to the employee. Now, the organization can discharge the employee. Suppose if the employee remains absent without any notice for a longer period of time. Say for 1 month, the employee is absent without any notice, without any prior approval from any authority. The employee has not contacted the organization. So this can be one of the reasons the employee can be separated. And here we can say the employee is discharged. Or if the employee is not well for a longer period of time, say for 2-3 months, the employee is not well, and in future also the employee will not be able to work as he was working priorly before he was admitted to the hospital. So that way, the employee, if separated from the organization, that will also be included by way of discharge. So permanently, the employee who is severely ill, and when it is proved by the doctors also that he is not in a condition, he will not be in a condition in future also to work which he was working prior. So that way, if the employee is permanently separated, we can say the employee is discharged. When we talk about dismissal, the examples can be when an employee is misbehaving with a superior, or he misbehaves with his colleagues, or he fights with his colleagues, and on number of times he has indulged into such type of activities, and if that employee is separated from the organization, that can be called as dismissal of the employee. If the employee has been held for, say, he was supplying confidential information of the company to another competitor company, and if it is proved, then it is called as a severe offense. Then the person is not discharged from the organization, then the person is dismissed from the organization. if the employee is involved in financial fraud in the company, and because of that financial fraud, if the person is separated, that separation will again be called as dismissal and not discharge. So the most important difference between two terms, dismissal and discharge, is that discharge is less severe punishment given to the employee by way of separation, whereas dismissal is a very severe punishment given to the employee for by way of separation. So that is the involuntary first type of involuntary separation, discharge or dismissal. Next one is layoff. Now, layoff is not permanent in nature, it is temporary in nature. We had just discussed discharge and dismissal, both are permanent in nature. The employee is separated from the organization permanently. But in layoff, we are saying the employee is separated from the organization for a particular time, temporarily. So that is called as layoff. Now, layoff, the meaning of layoff is when the organization is unable to provide employment to the employees in the organization for a temporary period because of certain things which are not in the control of the organization. That temporary separation is called as layoff. So there are certain things which are not in the hands of organization. For example, 5 employees were working on a machine. A single machine was operated by 5 employees. Now, this particular machine has, suppose there is some technical problem with this machine, and it will take, say, 5-6 days to correct that particular technical problem, to solve that particular technical problem. So for 4-5 days, till the machine again starts operating, again starts moving, these 5 employees will not be getting job in the organization, because their job was to operate that particular machine, and that particular machine now has some technical problem which will take 4-5 days to solve. Now, for this 4-5 days, if these 5 employees are not given employment in the organization, then it will be called as layoff of 5 employees. So it is temporary in nature for 4-5 days till the machine is okay. Next, now again, all of a sudden the machine broke down. It was not in the hand of the employer. It was not in the hand of the, or it is not the fault of the organization. So anything which is not in the hands of the organization, and because of that, if temporarily for some days, if the employment is not given to certain number of employees, then that is called as layoff given to the employee. It is always temporary in nature, never it is permanent. Now, second example can be, suppose there is a flood in that particular region where the factory is situated, and because of flood or because of earthquake, there was an earthquake. So because of flood or because of earthquake, there is damage to, say, 5-6 machineries. So all the employees who were working on these 5-6 machineries, they will not be given job employment for a period of say 10 days, 15 days, till the machines are repaired by the technicians. So that is again temporary unemployment for 5 days, for 10 days, for 15 days, till the machines are the damage of the machine is solved. So that is the meaning of layoff. Layoff is temporary separation of employees from the organization, is called as layoff. Generally, the conditions of layoff are not controlled by the organization. They are beyond the control of the organization. Now, for example, this COVID. Now, Corona has come, and because of Corona, if the organization is closed for a period of say 1 month, and for 1 month, if the employment is not being provided to the employees, that will be called as temporary separation of employee from the organization by way of layoff, because no one had control over Corona. So that is the meaning of layoff. Next one. Now, the next involuntary type of separation is retrenchment. Now, retrenchment is opposite of layoff. Retrenchment again is permanent separation of employee from the organization. In layoff, we had seen that the things were not in the hands of the organization. They were not controllable by the organization. And because of those conditions, the employees got separated from the organization. But that was for a temporary period. That is layoff. When we talk about retrenchment, retrenchment again, it is permanent in nature. But retrenchment of employee, that is permanent separation of employee, under retrenchment takes place when the number of employees are more than the required number in the organization. For the last 2-3 years, the organization is not getting enough orders. So the present number of employees in the organization are more. Earlier, when the organization was getting orders, then everyone was getting employment. But now the business of the organization is not good. So there is loss to the organization, and the organization feels that 30 employees are extra. 30 employees are extra, whom the organization is unable to provide employment. Now, these 30 employees, if they are removed because they were exceeding the number of employees required by the organization, then that separation will be called as separation by way of retrenchment. And retrenchment again is permanent in nature. It is permanent separation of these employees. But for retrenchment, there are two principles of retrenchment which the organization should always consider. First principle of retrenchment. Retrenchment, the meaning of retrenchment is permanent removal of an employee from the organization under a condition that the employee has become extra employee who cannot be provided job in the organization because of less business, 5 employees, 10 employees, 50 employees have become extra employee in the organization whom the organization cannot provide employment. So these employees, when they are removed, these employees will be called as retrenched employee, and that is the meaning of retrenchment. Now we were talking about two principles of retrenchment. First principle of retrenchment is last in, first out. When we talk about removal of employee or permanent separation of employee by way of retrenchment, it is not up to the organization that they can or it can remove any of the employee from the organization. But a principle has to be followed. That principle says that if you want to remove the employee permanently by way of retrenchment, you have to remove first the last one who has joined the organization. If the organization has decided that 5 clerks will be removed from the organization, then the last clerk who has joined the organization who should be removed. So this principle should always be kept in mind by the organization which is following retrenchment. Second principle is that whenever the organization is having vacancies for that particular position, suppose 5 clerks were removed, and after 3 years, again the organization is having good business, again the organization is recruiting more people. So whenever there will be the recruitment for clerks will be done, then the organization should contact these 5 clerks first, that now again we are into good businesses, and there are vacancies for clerks in the organization. If you are interested, you can come for the interview on so and so day. So these two principles should be kept in mind when the organization is implementing the concept of retrenchment. Next one, voluntary retirement scheme or VRS. Now everyone has heard of this word VRS or voluntary retirement scheme. Now before attaining the age of retirement, when an employee separates himself from the organization before he attains the age of retirement, that is called as that the employee has opted for VRS or voluntary retirement scheme. 5 years of the employee's service were there, but before completing those 5 years, he has opted for retirement from the organization. So that retirement will be called as voluntary retirement scheme. Now, these schemes are generally given because when the organization feels that there is surplus employees, more employees are there, and the organization is unable to provide employment to all the employees. So the organization can implement this scheme, which is called as voluntary retirement scheme. This scheme can be circulated to the employees of the organization who say 5, 6, 7 years are remaining. Now these employees, whosoever feels that this particular scheme is beneficial to him or her, he or she can opt for voluntary retirement scheme. That means again, this scheme is also permanent in nature. The person who is opting for VRS means that he is permanently separating him from the job or from the organization. So again, it is permanent separation. Next one, downsizing. Now, downsizing is again removing the extra employee from the organization. When the organization feels that certain number of employees are extra, and after fulfilling all the requirements under various laws, if the employee removes certain number of employees from the organization, that is called as downsizing. Downsizing means that earlier 100 employees were working in the organization, but now the organization is unable to provide employment to all the 100 employees. The organization is of the opinion that 20 employees have become extra employee who cannot be provided employment by the organization. So after following the various requirements under various laws, the organization can remove these 20 people from the organization, 20 employees from the organization permanently. And this separation will be called as separation by way of downsizing. Now, the meaning of VRS, nowadays it is very much popular. What is VRS that we will be discussing? So in short, we have discussed the meaning of VRS. Now, VRS is one of the strategy introduced in early 1980s in central public sector units. Now, we all know why this VRS concept was introduced there, because it is very difficult to remove a permanent government employee from the job. The laws, the rules are very strict in nature. And when the rules are very strict, the employees, they do not perform. They stop performing because they know that even if they perform or not perform, there is no chance that they can be removed from the organization, because the rules are very strict in nature for removal. So it was realized by the public sector units that, or government controlled organization, that when it is difficult to remove the non-performing employee, they should come up with some sort of scheme which should attract these employees, and these employees should themselves get separated from the organization. And for that particular reason, voluntary retirement schemes were introduced in public sector units. That, and these schemes were made very attractive. For example, the employees were given the option that, okay, your 5 years are remaining, we will pay you complete salary of say 5 years if you retire from the organization right now, or we will pay you say salary of 3 years or 4 years complete salary if you retire just now. So they were given the idea, the employees were given the idea by the organization that this much of amount you will be receiving right now if you retire from the organization. So instead of waiting for 3 years or 5 years to complete their tenure, if they retire right now, they will be getting a handsome package from the organization. So many of the employees get attracted towards this package, and they retire from the organization. So that is the meaning of VRS. Now there are certain benefits of VRS. First one, uh, provident fund. We have already discussed during our last lectures that provident fund, what is the meaning of provident fund when we were discussing components of compensation. So provident fund is associated with that package of VRS. Then encashed accumulated leaves, they can encash the accumulated leaves also. Accumulated leaves means the leaves which have been deposited by the employee. Suppose a employee is entitled to 15 leaves in a year and he has not taken those leaves. So those leaves get accumulated, get deposited. So at the end of the employment, he can encash those leaves also. So these leaves are also can be encashed by way of it is added to the VRS package. Then gratuity is also added to the package. Then salary for the notice period and cost of transfer to the hometown. So it is a all inclusive package. Now to attract, to make the package attractive, various things are included in the package, that we will be providing you this, which you may not receive or which you will be receiving after 5 years. We can provide you right now before 5 years if you opt for retirement. Now, generally, these VRS schemes are designed for people who are not productive for the organization. But as there only 3, 4, 5, 6 years are remaining, and it is very difficult to remove these people because of strict laws, then the organization designs a package which is called as voluntary retirement scheme, which is very attractive and which is shown or which is given to the or which is promised to the employee, that this is the package which you will receive right now if you retire from the organization right now. If you do not accept this package, then you will be receiving this after say 5 years once you retire from the organization. And many employees get attracted, okay, why to wait for 5 years to get all the money? So they immediately accept the VRS package. So that is the benefit of various VRS packages. Next one is golden handshake. Now again, golden handshake is considered as one of the VRS package. Various things are included in VRS package, which makes it very attractive. Now, golden handshake. Golden handshake means that when an employee receives more benefit which he or she was expecting from the organization, it is considered as golden handshake. Now, say 10 years of the employee's service is remaining. And if the employee is promised that you will be given a salary, complete salary for 5 more years. 5 more years. 5 more years is that 10 years are remaining. If you retire right now, then you will be given salary of 5 years, and whatever provident fund gratuity which has been accumulated in your account, that will be given, plus leaves, extra leaves, salary will be given. So all this type of package is designed, which the employee feels that yes, it is very much beneficial to me. Now here the employee may feel that if I leave the organization now, I have an opportunity to work in other organization also. So I will start working from say next month. And from this organization, I will be getting salary of a salary package, a complete package for the next 5 years also. So he has retired from his present job, but he is getting extra 5 years salary where he will not be working in that organization. So what he feels is he will be working in some other organization, but he will be getting salary of extra 5 years from this organization. So it is a very profitable type of say deal. So he can opt for that deal. So that is the meaning of golden handshake, where the employee feels that the deal is a golden deal for me. He is getting paid for extra 5 years where he will not be working for the organization. And for those 5 years, instead of sitting idly at home, he may start working in some other organization. Now, one of the generally these VRS packages are designed for the people, for the employees who are non-productive employees. But sometimes what happens is, sometimes these schemes are so attractive that good performers of the organization also get attracted, and they also avail this scheme. Now, that is the demerit of this scheme. The reason for designing this scheme is, as the laws are very strict for the removal of permanent employee. So the organization had thought that if they give a very attractive package to a non-productive employee, that non-productive employee will definitely accept that package, and he will leave the organization permanently. That is the idea behind this package. But sometimes what happens is, because these packages are attractive, the good employees, the best performer, the better performer of the organization also get attracted towards these packages. They also accept these packages. They also leave the organization and they start working in some other organization. So that is the demerit of, or disadvantage of the concept of voluntary retirement schemes. And one of the voluntary retirement scheme is called as golden handshake. The next one is the grievance handling procedure. Now, grievance means a complaint. So the basic difference between complaint and grievance is, complaint can be oral in nature, complaint can also be written in nature. Complaint can be of the conditions of employment, or complaint can be personal in nature. Whereas when we talk about grievances, grievance, the meaning of grievance is a written complaint which is related to conditions of employment, is called as grievance. So whenever an employee files a written complaint for any injustice, or if he is not happy with any of the rule in the organization, or if he feels that the supervisor or some colleague or some superior is unnecessarily harassing him, if he files a written complaint regarding that harassment, then that complaint will be called as a grievance. Now, how these grievances are to be settled, every organization has a policy for that grievance redressal policy or grievance solving policy that we are going to discuss. This grievance procedure is general grievance procedure. It is not that every organization has to follow this grievance solving procedure as it is. It is a general procedure. Now, why these procedures are there in every organization? Because if there are grievances which are not solved, if there are complaints which are not solved, it will create unrest among the employees, which will not be good for the organization. If there is unrest in the organization, it will definitely affect the production adversely, which will affect the profitability of the organization also in the long run. So it is expected that every organization should design a grievance solving machinery. Whenever any employee is having any grievance, the employee should be aware of that who is the authority where he can go or he can send his grievance for settlement. Then who is the next authority if the grievance is not settled? Then who is the next authority and who is the final authority? That is the grievance handling machinery, which every organization should have. So we will be now discussing a very general grievance handling machinery. So first one is, it starts with aggrieved employee. Aggrieved employee means the employee who has to who has a complaint against another employee or against any say rule or against supervisor or against any superior which is related to work condition. So that employee will be called as aggrieved employee. So first, the aggrieved employee should go to the departmental representative. So whosoever has been given the charge that if the employee, lower level employee, is having any problem, first he should be going to the departmental representative. Then here the timing is also given. Within 2 days, within 48 hours, the departmental representative has to solve this complaint. If it is solved at that level, then it is considered as yes, the complaint is solved, and the complaint or the grievance will not proceed further to the higher authorities. It will be settled there only. If it is not settled there only, then it will move to the head of the particular department. It will be there with the head of the department for 3 days, and it is the responsibility of the HOD to clear that grievance. If the head of the department is unable to solve that grievance, then the grievance will proceed further to the grievance committee, and it will be there for 7 days. Then it is the responsibility of the grievance committee that within a period of 7 days, they have to settle this grievance. If because of some reason they have settled the grievance, but the result or the solution for that grievance is not acceptable to the employee who has filed that grievance, then it will be called as unsettled grievance. Now, this unsettled grievance will move to the further authority, and that authority is chief executive. So there can be chief executive, general manager, or the highest authority. We can say the highest authority of the organization. It will be there with the chief executive for 7 days. Within 7 days, the chief executive is supposed to solve that particular grievance. If it is not settled by the acceptable by the say settled by the chief executive, or whatever settlement the chief executive has suggested, if the aggrieved employee is not accepting that solution, then it will move further to the voluntary arbitration. Voluntary arbitration means third party involvement. Now, this third party is acceptable to the organization, is acceptable to the aggrieved employee also. Now, here aggrieved employee feels that as the complaint is related to a superior authority in the a senior authority in the organization, so everyone in the organization, so every machinery, every settlement, grievance settlement machinery is with that particular person only, and he feels that there is injustice being done to him. So that grievance can move to voluntary move arbitration. Voluntary arbitration means the third person can be involved, expert can be involved, who can help to solve this particular problem or this particular grievance, which is acceptable to the employee, which is acceptable to the uh, organization also. Now, this person can be lawyer, this person can be a person who is, say, a social worker, this person can be a politician, this person can be a person who is acceptable to both the parties. Both the parties, one of the party is the organization, the other party is the aggrieved employee who feels that there has been injustice done to him. So this is the settlement of grievances, which the every organization should have. Now, this is considered as the model grievance handling procedure of the organization. Now, what will happen if the still the result is not acceptable, solution is not acceptable to the aggrieved employee? The organization has tried everything, but the employee, aggrieved employee, is not satisfied with the solution. Then what will happen? Then, if still the grievance remains, then the grievance is forwarded to the grievance settlement machinery, which is formed under Industrial Dispute Act 1947. Now, this which we have just now discussed is the machinery, grievance settlement machinery, which is prepared, which is made by the organization. Now, if we talk about the other grievance machinery, now this grievance machinery, which now we will be discussing in brief, is a machinery which is prepared, which is made by law, which has to be followed by all the organization. So if this machinery fails, machinery, grievance settlement machinery of the organization, if it fails to solve a problem, solve a grievance, then that grievance can be forwarded to the grievance settlement machinery, which is made by law. Now, that machinery consists of various stages. First stage is the works committee. Second stage is conciliation officer. Third stage is board of conciliation. Fourth stage is court of inquiry. Fifth stage is the labor court. Sixth stage is industrial tribunal, and final stage is national tribunal. Now, this aggrieved employee can file his complaint to the grievance settlement machinery under ID Act 1947 also. So first he has to go to the works committee. If he is not satisfied, then he will move to the conciliation officer. Not satisfied, then he can move to the he can go to the board of conciliation. Not satisfied, then he will move to the court of inquiry. Not satisfied with the result, then the aggrieved employee can move to the industrial tribunal. Now here the industrial tribunal and the national tribunal, they have separated the that what are the issues which can be forwarded to the industrial tribunal, what are the cases which can be forwarded to the national tribunal. They are fixed. If the case falls within the jurisdiction of national tribunal, it will go to the that complaint will go to the national tribunal, and the decision of national tribunal is considered as final decision, which has to be accepted by the organization as well as by the aggrieved employee. So this was regarding our fourth chapter. If you are having any doubt, you can raise your doubt now also, or we can discuss that query in our next lecture also. Tomorrow there will be no session of human resource management at 6 a.m. We will directly be meeting on Monday at 6 a.m. Thank you for joining today's session. We will stop here now. Thank you.
Thank you, sir.
Thank you.
सर वो डायरेक्टर सर से बात कर लेना है.
Yes, yes, yes.